All right. Good afternoon, everyone, and thank you for joining us. Before we begin, I wanted to share a few quick updates. My name is Xander Heinen. I'm the president of FinLink. So what's been happening at FinLink over the past couple weeks? We've really been hard at work on the continued rollout of what we call FinLink 2.0, which represents a major evolution of our platform. Our goal is to make FinLink the central environment where financial advisors, RIAs, broker-dealers, accounting firms, insurance agencies, buyers, sellers, recruiters, lenders, vendors, you name it, can connect and do business. We have been expanding beyond our legacy M&A marketplace into a broader platform that includes succession planning, recruiting, jobs, business directory profiles, company pages, social engagement, our new valuation tool, financing tools, and other resources designed to help professionals grow, transition, buy, sell, recruit, and collaborate more efficiently. A major focus for us has been creating more education, better connections, and more practical resources for advisors as they navigate increasingly complex client, business, and succession needs. With that in mind, I'm excited to welcome Antony Joffe, Chairman of Sterling Trustees, and Melissa Williams, Senior Trust Officer at Sterling Trustees, for today's trust discussion on trusts, South Dakota trust laws, and why these structures matter for RIAs working with high net worth and ultra high net worth families. As the great wealth transfer continues, advisors are being asked to support more complex estate planning, tax, asset protection, and multi-generational wealth strategies. Trust planning can be a powerful way for RIAs to deepen client relationships, retain AUM across generations, and work more efficiently and effectively with attorneys, CPAs, and family offices. Antony helps lead Sterling's vision and strategy and has more than 15 years of trust industry operating experience. He has helped Sterling grow to over $10 billion in assets under administration and is also a co-founder of Wealth Hub and the South Dakota Trust Association. Melissa is a senior trust officer and certified trust and fiduciary advisor. She specializes in business development and fiduciary services with experience administering complex assets, closely held business interests, LLCs, LPs, insurance, and marketable securities. With that said, Antony and Melissa, thank you both for joining us. We're excited to have you here, and I'll throw it over to you guys.
Great. Thanks, Xander. Appreciate the intro. And, Melissa and I today are going to walk you through trusts, what they are, why South Dakota, and then maybe just tell you a little bit about Sterling and how we, help RIAs within the trust and estate world. So with that, I'm going to turn it over to Melissa, who's going to walk you through the first few slides here.
Okay, thanks, Antony. As Antony said, why trust and why South Dakota? As an RIA, trusts are a specific tool that can help protect and grow your AUM. Let's start at the basics, right? This is a refresher, a primer for everybody. What is a trust, right? You've got your grantor who creates the trust, funds the trust. You've got a trustee, it can be an individual or, in our case, a corporate trustee who's an independent third party, unbiased to family relations, etc. Their job is to manage the trust assets. They do the administration of the trust. They make sure that the trusts are invested appropriately according to the terms of the document. And then we've got the beneficiary, right? The beneficiary is the one who benefits from the trust assets. Key distinctions for trusts, right? They're a separate legal entity. Once the money gets into the trust, it's its own entity. It pays its own taxes, if it's a non-grantor trust, etc. Great things about a South Dakota trust or trust in South Dakota is that they can span for multiple generations with no expiration, right? So you have a grantor creates a non-grantor dynasty trust for their family. A great sticking point is when you have marketable securities and managed assets with an RIA, the grantor dies or a beneficiary dies, potentially you have the opportunity to hold on to that business, retain the AUM, and continue serving the family for multiple generations. Go to the next slide, Antony. We've got common trust structures. A lot of times we'll see revocable living trusts with grantors. We'll hire Sterling Trustees as the corporate trustee, and then they retain the control over the assets and management and things of that nature. We work a lot with irrevocable trusts in families where assets are permanently transferred out of the grantor's estate for tax planning, and multi-generational, planning to receive, the assets for multiple generations. And then we'll talk a little bit more about dynasty trusts further on in the presentation. And I keep saying multiple generations, right? A dynasty trust is designed to last for years and years and years. And we've seen, a lot of clients on their fourth generation of families that continue to receive benefit from, their great grandfather's business that they had liquidated years ago, right? So it's kind of an amazing tool that business owners and individuals of wealth can utilize to ensure that their legacy lasts for a long time. Directed trusts are a specialty tool that we have here in South Dakota, where Antony will go into the structure in a little bit, but you've got your administrative trustee, which would be Sterling Trustees, and then a specific investment advisor, an RIA, an individual that can manage the assets of the trust. From time to time, we'll see special needs and charitable trusts, but those don't come up too often. You can go into the next slide, Ann. And again, why trust matters for RIAs. The numbers don't lie. $84 trillion is expected to transfer hands through generations by the year 2045. So there's a huge opportunity for wealth for individuals of high net worth to put their funds into a trust for long-term multi-generational management. 60% of these high net worth clients have trust needs, right? So they may have complex family matters. They may have high estates where they have to pay, an estate tax or estate tax. So the need is there, and Sterling Trustees could be a potential partner to work with. And again, the numbers don't really lie. It's 3 times AUM retention rate with trust services, and that kind of goes back to the multi-generation, right? If you have multiple beneficiaries of a trust, one of them dies, you still are servicing the family because it's going to be remaining in a trust instead of an individual passing, and then the individual beneficiaries taking their assets to another advisor. So I think that's it there.
Yeah.
And Antony, I'll turn it over to you. If there's any questions, we can pause too.
Yeah. Why does situs matter? And situs is, I guess, a fancy legal term for, what's the governing law of the trust, and that does really matter. I mean, we live in a great country where we have 50 different states, and the great thing is we have 50 different trust laws, and we as the consumer get to take advantage of that and pick, the best trust law that really benefits us the most. And I think this is an area where a lot of people just aren't knowledgeable about that and don't know really how to take advantage of that. And really, trust laws are really sort of broken down, I would say, into really sort of 4 buckets here. You can see sort of taxation, asset protection, legal framework, and privacy. So taxation, a lot of states, including South Dakota, have no state income tax or capital gains tax on trust assets, which really allows you to compound those assets much quicker by not having to pay state income tax, where, take California, for example, you're paying a 13% state income tax. Asset protection, trusts are a great way to protect assets, and the amount of time that the assets sit in there really allows it to cure, and South Dakota's got one of the shortest cure periods, and we'll talk a little bit about that a little further. And then there's sort of just the legal framework of trusts. Can you have a trust that goes on forever? Is it very easy to move trusts from other states into your state? Do they have the directed trust statutes? And then privacy is also a big one. A lot of people don't want people knowing about their trusts, who's involved, and can courts get involved in this, or do beneficiaries have to be notified about trust? So these are all sort of things you need to think about when picking a trust situs. So South Dakota today really has probably the best, trust law in the country. There's more bank and trust assets in South Dakota than any other state in the country by a factor of 2. So it dwarfs Delaware. I think you could take some of the other tier 1 states like Nevada, Alaska, New Hampshire, add them all together. You don't get to what, South Dakota has. And that's been proven by, Trust and Estates magazine has ranked it as sort of the #1 state in the country. A lot of that is predicated on, no state income tax and the ability to have trusts that go on in perpetuity. The thing that we like about South Dakota is the legislature is very active in looking at trust law on an annual basis. The legislature or the Department of Banking takes puts new rules into effect on an annual basis. So they take a bill through the legislature. So there's this process of continuous improvement. And South Dakota is just also a very well-run state. Runs a balanced budget. Their pension liabilities are 103% funded. They've got no state income tax written into their constitution. So the risk of a state income tax coming into being is very, very low. And here are some of the other key advantages, and we'll talk about this on the next slide. So the big, really 5 advantages for South Dakota are obviously #1 is no state income tax or capital gains tax. And again, this is really a great way to sort of defer state income tax until you make a distribution back into your home state where the beneficiary would pay the tax. But until then, you don't have to pay any tax in South Dakota. And again, for families that are if you've got clients in high tax states like California, New York, Illinois, Connecticut, where you're paying upwards of 13% state income tax, this is a great advantage to be able to compound your assets, state tax free. South Dakota was one of the first, well, actually was the first state in 1983. They repealed the rule against perpetuities, meaning you can have a trust that goes on forever. So this allows families that, you could use your lifetime gift exemption now. So if husband and wife could put $30 million in GST tax free into a trust, and that trust can go on forever. You never have to pay any generation skipping tax, and there would be no end to the trust. And so really powerful way to compound assets over time. South Dakota is also the first state to create the directed trust statutes. And this is really, really important item for RIAs. And we'll get into that on the next slide and how this can really help your practice and grow your practice and really make the assets in your practice much more sticky. South Dakota has also got great asset protection, and it's got one of the shortest cure periods of any state in the country, other than Nevada. Also has a 2-year look back. So once the assets are in trust for 2 years, they become bulletproof for creditors. South Dakota's also got what's called a self-settled trust, where the grantor putting money into the trust can also be a beneficiary of that trust, as long as you've got a third-party trustee in South Dakota making those distribution decisions. So it's a great way to get money out of your name into a trust, have it asset protected, but also still be able to benefit from it. And then privacy, sort of 2 parts for privacy in South Dakota. One is most states at the age of 18, you've got to notify the beneficiary of an existence of a trust. And you can imagine an 18-year-old kid going off to college finds out they're the beneficiary of a $100 million trust, sort of a great way to stifle their ambition. And South Dakota is silent as to that. So you don't have to notify the beneficiaries, and it's a great way to protect them. The other part to privacy in South Dakota is if a trust is ever made part of a lawsuit, you can have the trust permanently sealed in South Dakota, so it'll never see the light of day. And where we see this most often is beneficiaries going through a divorce, outgoing spouse wants to attack the trust to potentially get more alimony, and South Dakota will shut that down. I can go into court, have the trust permanently sealed, and the divorce attorney of the ex-spouse will never see the trust document or statements. And so again, great way to sort of protect the beneficiaries. So one of the most important probably laws for South Dakota are what's called a directed trust. And this is really, really important for investment advisors. So as Melissa explained earlier, in the typical trust structure, you've got the grantor who's putting the money in. You've got Sterling trustees who potentially is the corporate trustee. We administer all the assets, process any distribution. We maintain the records, do the fiduciary reporting, tax reporting, and whatnot, and make sure that the beneficiaries are taken care of. But in a directed trust in South Dakota, there's two other individuals that are added to the trust document, and they have two distinct roles. One is the distribution advisor, and the other is the investment advisor. The distribution advisor that's appointed, they make all the distribution decisions. So it could be somebody that's close to the family that knows them, and they would make all the distribution decisions. And all they do is they direct us as the trustee where to send that money to. So it's a way to give family a little bit more control versus having a corporate trustee like us making those distribution decisions. If they want a family member to have that power, they feel like they have a little bit more control and whatnot. On the investment advisor side, this is really where it's powerful for the RIA and the RIA firm is you guys can be appointed as the investment advisor in the trust. So now you have a long-lasting relationship with an existing client. You want to have continuity to the next generation. Talking to them about a directed trust and naming you as the investment advisor in the trust allows you to have that continuity to the next generation. Because I don't know if you know the statistics, if your client's assets aren't in trust when they die, chances of you holding on to them for the next generation are about 80%, about 20%. If they're in trust, it's about 80%. So it really behooves you to be having these conversations with your clients so that you have that continuity to the next generation. The other great statistic about trust is, the average agency account in an RIA has a life of about 7 years. A trust account has a life of about 17 years. So again, makes the assets much more sticky and makes your book of business much more valuable if you get to some point of time here where you want to monetize that and whatnot.
Antony, let me just stop you there.
Sure.
We're going to hold the questions for the end. I see some people raising their hand. If you just want to drop your question in the Q&A box on the bottom of the screen, we can get to that at the end of the presentation. Thanks so much.
Sure. So I'm just going to run through a couple of case studies that might be of interest. We recently worked with a family, about $45 million of assets, actually based in California. And between federal tax and the state tax in California that he was paying, it was just eroding sort of the trust principal and income, and was nervous that his grandchildren were never going to be able to benefit from some of these assets. And the RIA was also potentially going to lose the account. So when he died, they were going to use a corporate trustee, and they would take custody of the assets and manage the assets. And so between us and the RIA, we were able to go to the family and say, listen, hey, move the trust out of California into an irrevocable dynasty trust that can go on forever. We would be the independent corporate trustee. The existing RIA got to continue to manage those assets going forward. And now they got the benefits of South Dakota, zero state income tax, no rule against perpetuities. They appointed up trust protectors so that there was a government, multi-generational governance going on. So all in all, it was a great outcome for the family. $18 million of estate tax savings. Family wealth was preserved, but more importantly for the RIA, he got to retain those assets across multiple generations now. So it was a win-win for him. Another situation we recently had, a woman, she was a neurosurgeon, had saved about $8 million of assets. You can see in her mid-50s. She was really nervous that, what happens if, for example, she removed the left side of the brain instead of the right and, opened her up to, potential liability. How could she protect her assets? And this is really where self-settled trust, came into being. So she was able to move the $8 million out of her name into a self-settled trust. They sat there for 2 years, and now they're bulletproof for creditors. And she also gets to enjoy that money because she can be a beneficiary of the trust and use some of those assets, for her benefit. So again, sort of the outcome, we effectively, shielded $8 million from any malpractice claims. She gets to be a discretionary beneficiary of the trust and get to enjoy those assets during her lifetime. And she also gets the benefits of South Dakota now, zero state income tax. And you can see what the savings on an annual basis was there. So when choosing a trustee, I guess really at the end of the day, you've got sort of three choices. You've got sort of a non-depository trust company like ourselves that purely acts as a trustee. We don't manage any assets ourselves. We don't custody any assets. We allow the RIA to continue to custody assets so they're not held away and they've got better control over them. and you can kind of see what the benefits of doing that is. You remove a lot of the conflicts of interest. We don't have the brand name that maybe a Northern Trust or a Bank of America has, but we work on a fixed fee basis. We don't charge on AUM, and so you eliminate a lot of the distribution bias and conflicts of interest that happen at a big bank trust company. Obviously the second opportunity is go to a bank trust company. You obviously get the institutional stability and brand name recognition, and an entity that's going to be around for multiple generations. But with that comes other products that they can sell you. They work on an AUM basis. It's bureaucratic. Trying to get a distribution out of a bank trust company, sometimes you want to shoot yourself because they make you stand on your head to get that money out, because if they distribute money out, it lowers their AUM, which lowers their fees, and it just leads to a ton of issues. The other way to go, obviously, is to appoint an individual trustee, and that has its benefits. Obviously, doesn't cost you anything, but for a lot of family members, being a trustee or being appointed a trustee, might be a great honor, but they don't really understand the liability that they take on in that fiduciary relationship and what issues that can lead to. Particularly where we see it most is father names oldest son as trustee, and now younger brother, younger sister have to go to him to get a distribution, and you can kind of see the conflicts that can create. And the other big issue with individual trustees are typically people, when they appoint the trustee or the individual trustee, they're appointing somebody that's typically their same age, and so when they die, they're likely going to die right behind them. So there's no continuity, and it's tough to pick sort of the right person that's knowledgeable about trusts, tax, accounting, investments, to hopefully do a good job for the family at the end of the day. So, why choose Sterling? As we've sort of talked about today, I mean, we're completely independent. We're not owned by anybody. We purely act as a trustee. We don't manage any assets. We don't custody any assets. We allow the RIA to work with any custodian they want. All we do is get a feed from that custodian into our trust accounting platform so that we can manage the assets on an ongoing basis. You get through South Dakota, obviously you get access to the directed trust model. So now you can control investments, you can control custody, and not have to worry about the trustee firing you or whatnot. You're written into the trust document, and so you have that perpetual investment management going forward across multiple generations. We're obviously South Dakota domiciled, so you get all the benefits that we just talked about. And we really are just built for high net worth, ultra high net worth families, family offices. Today we administer over $11.5 billion across 500 trusts and 200 families. And so I think families come to us because they appreciate, the service, the quick service, the ability to turn around distributions quickly, and there's no bureaucracy. So it allows them to feel like we almost act like an individual trustee for them, because we become part of the family because we don't have all that bureaucracy. Our trust officers are long-term employees of our firm and become entwined in all their lives. So I'm going to stop there. I know I tend to talk kind of quickly, and I'm sure there's lots of questions, so I'd like to open it up for them.
Yeah, thank you for that. I knew this question was going to come up, and I had mentioned it in my kind of plain vanilla layup questions, but ties into our first question here. For clients currently living in high tax states, how can a South Dakota trust potentially improve the planning outcome? I think you touched base on that, but we did have a question coming in around California.
Sure.
Don't California residents still have to pay California taxes if they intend to stay there?
Yeah, no, good question. So really, a South Dakota trust for a California person really becomes a state deferral opportunity. So what you can do if you've got an existing California trust is you can decant it into a new South Dakota trust. So you basically create a mirror image of the existing trust in California, and then you pour over the assets into the new trust. And there, the assets can compound state tax-free until a beneficiary wants a distribution. When the beneficiary wants a distribution, the distribution will get taxed in California. So it's a way to defer it, but obviously you get to compound your money. If you don't need those distributions annually, you can compound it obviously at 13% before any investment advisor has any additional return on that money. So it's a really great way to compound your money.
And then a follow-up to that from the same gentleman. Can distribution advisors be the same as the grantor?
No, never a good idea to have the person making the distribution decisions also be the person putting the money into the trust. I just want to go one other important thing just about California, because they do have their fingers into everything. The key to making the directed trust work in California is anybody acting in a fiduciary position within the trust. So we talked about the directed trust, the investment advisor, the distribution advisor, the trustee, or the protector cannot be California people. If any of those people serve in those roles, the trust would be considered a California trust. So the key is to have all those individuals outside of California, if possible. If you don't have people to serve in the distribution advisor or investment advisor role, we at Sterling can act in that role. So we would, oversee the investment oversight and make all the distribution decisions. That way, you have the trust completely outside of the California system.
Excellent. Good to know. Is the directed trust a distinct trust or a selection that is implemented in all other South Dakota trusts?
Yeah, so a directed trust is think of it as a form of administration. So there's sort of two different trust models in South Dakota. One's what's called a delegated or discretionary trust. So in a delegated discretionary trust, we as a trustee delegate out the investment management to a third party. So we could delegate out to the RIA, and then we have investment oversight over them. So typically on a quarterly basis, we'll get on the phone with the investment advisor, review the portfolio to an investment policy statement that we put in place, and we make sure they're doing what they're supposed to be doing. And then we'll make all the distribution decisions. So it's very similar to the bank trust model, other than we're delegating out the investment management to best of breed third parties to manage versus that internal model at the bank trust company, which we all know is terrible, is high costs and poor returns. With the delegated model, you can delegate out to, best of breed advisors. And then you've got the directed model, where we as the trustee, all we're doing is acting in an administrative role. The investment advisor and the distribution advisors are making all the decisions. And so the other key thing to know about the directed model versus the delegated model is in the directed model, the investment advisor and the distribution advisor have all the risk in that model. Distribution advisor makes a bad distribution decision and beneficiary wants to sue them, they're on the hook. We as a trustee have no theoretical liability. Same on the investment advisor side. They take $10 million of assets, turn it into zero. It's all on them. We as the trustee have no risk. In the delegated model, it's the opposite. We have all the risk along with the investment advisor. So again, investment advisor takes 10 million, turns it into zero. We, along with that investment advisor, are on the hook. And if we make a bad distribution decision, we're on the hook. So the directed model, the fees tend to be cheaper because there's less risk on the trustee. In the delegated model, the fees are higher because we have more risk. And so it really just depends what the family wants and if they have people to serve in those distribution and investment advisor roles.
Excellent. Next question is two-part. How do you deal with insurance assets held in a trust? And also, can special needs trusts be incorporated in your trust structures?
Yeah, no, two good questions. So we do ILITs, which are trusts that hold insurance for beneficiaries, and they take multiple forms. I mean, it could just be a straight universal policy, or it could be PPLI or premium finance based policies. But yeah, we would act as the trustee. We would pay any premiums that are due. Provide any crummy letters that need to be provided if it's a crummy-based trust, and then obviously on death, if there's cash now in the trust, we would work with the family to appoint an investment advisor to manage those assets, and then have that continuity going forward in terms of making distributions to the beneficiaries and whatnot. Yeah, South Dakota is a great place to put special needs trusts. Unfortunately, this is an area where we just don't have a lot of experience, and wouldn't want to practice on any of FinLink's clients or whatnot. But yeah, it's just not. There's a lot of special trust law around special needs, a lot of orphan court reporting, Social Security, Medicare, and that kind of stuff that needs to be reported and whatnot. So it's not an area that we practice in, but there are a number of South Dakota trust companies that do specialize in this that would be helpful.
Excellent. Are these trusts set up in grantor social? How does it work with multi-generational as far as tax ID? Are you familiar with a non-grantor federal trust?
Yeah, so a trust either is a grantor trust or a non-grantor trust, and really the difference between the two, a grantor trust, the grantor who puts the money in pays all the income and capital gains tax at the end of the year. A non-grantor trust, the trust has its own tax identification number. It pays any taxable income or capital gains at the end of the year, less any distributions that it makes out to the beneficiaries who would also pay whatever tax or income tax or capital gains tax that would flow through to that. So yeah, so we work with either. It really just depends what what the family's looking for, or how how the attorney structures the particular trust. But it can go either way.
Last one I have here. For irrevocable trusts held in most other states, when the grantor is the beneficiary, are they exposed to liabilities or divorce compared to certain other states, such as this South Dakota Citus Trust? Trying to make sure I understand the extra protection and benefits of the SD Trust versus e.g. California Trust.
Yeah, so hard to protect assets from a divorce in South Dakota unless those assets are put into trust before you get married. It's hard to, if you've got existing assets that you and your wife both put into the trust and then you get divorced, try to protect them. But if your assets are in trust before you get divorced, before you get married, obviously you can protect them, in South Dakota. And again, obviously California is a community property state, and but if the assets are out in South Dakota, they're protected. And again, a California divorce attorney would have to go in front of a South Dakota judge to be able to get access to any of those documents or statements or anything like that. So it's just sort of another roadblock you can put in front of a ex-spouse's divorce attorney to, hopefully try to make their life miserable as possible.
And then I'm not shocked by this, but the California question we seem to be hung up on, but I'm not shocked by this. Following up on the California point, how is residency determined when an advisor is an entity rather than an individual? i.e., if I appoint investment advisor or distribution advisor that's an RIA, is it their principal place of business where my RM lives or where the company is domiciled, i.e. Delaware?
Yeah. Yeah, so really it depends on who gets appointed. If it's the entity itself that would, control the situation, or if it's a person, if the person's named in the trust, then it's, where their individual domicile is. California is, as I said earlier, just is a really, really tricky state. One of the other things that South Dakota has recently developed is what's called special purpose entities. And so you can have a special purpose entity now, which is, think of it as like an LLC, South Dakota LLC, and that entity can act as a distribution advisor or investment advisor. And so you can have theoretically a South Dakota entity with a California, person acting as the manager of that LLC. And, we always recommend that the family also adds maybe some non-California people as LLC managers as well. And so there's a way to maneuver around some of the California stuff with the use of special purpose entities. So they're starting to become very, very popular in terms of, creating trust, because the nice thing about these special purpose entities are you can get insurance for them so that you're protected when making decisions as the LLC manager for that entity.
Are there any other questions that need to be answered? Otherwise, we're gonna wrap up here. Well, I do see that you guys have your info on the last page here. Feel free to take down that information, folks. Also, we do have a lead form through FinLink. You can get a hold of Sterling Trustees via that lead form as well. Antony, Melissa, I want to thank you for joining us today. That was really great. That's very valuable insight into trusts, something that not everybody knows all that much about, especially South Dakota trust law, and how RIAs can think more strategically about serving high net worth and ultra high net worth families, multi-generational as well. For everyone who joined, we appreciate you taking the time. Hopefully, this conversation can give you a better understanding of how trust planning can help deepen client relationships, protect assets, and help advisors retain AUM across many generations. If anyone would like to learn more or discuss a specific client situation that we need to get a little more in depth with, we'd be happy to make an appropriate introduction to the trustee team at Sterling. Thanks again, and we look forward to seeing you at the next FinLink webinar. Thanks again, Melissa. Thanks, Antony.
Thank you. Thanks for having us.
Have a good one. Bye-bye.